विद्यार्थियों, first of all, we read this quotation. हार यानी पराजित होना, तो वह सबक है जो आपको बेहतर होने का मौका देती है. It means हार is not a curse, but it is a boon also. It is a boon, not a curse. So don't be harassed about such defeat. Because it provides you to reform yourself. Okay, that's all. We start to solve the question. The first one, the provision for the relevancy of fact is contained. It means in which section relevancy of fact is contained. I have told you relevancy of fact is contained in Indian Evidence Act second part of the act from the section 5 to 55. From the section 5 to 55, relevancy of fact is contained, and it is second part of the Indian Evidence Act. Okay, so here is asked sections, section 5 to 55, and second part of the Indian Evidence Act is relating to the relevancy of the facts. So option 1, it means A, is correct answer. Okay, second, which one of the following sections of the Indian Evidence Act 1872 provides that evidence may be given of facts in issue and relevant fact? It means which one of the following sections of Indian Evidence Act provides the evidence may be given of facts in issue and relevant fact? Section 5. Students, you have to understand that Evidence Act is relating. Indian Evidence Act is relating to two things. The first one is to establish the fact. And the second is to prove such fact. It means it tells rules. With the help of such rules, any fact is proved. With the help of such rules, any fact is proved. So, it is said, it is known, Indian Evidence Act tells about two things. It is said, what? To establish the facts, and the second one is how to prove such fact. These two things are mentioned in Indian Evidence Act, and you can say that these are two main objects of Indian Evidence Act: establishing the fact and proving the fact. But if the second object be, see, to prove the fact, it means proving the fact, evidences are produced. But what type of evidences are produced? These are mentioned, these are told by the Evidence Act. So, we have to learn that how the evidences are produced. These rules, these principles are mentioned by the Indian Evidence Act. According to it, evidences, what type of evidences shall be proved, shall be produced before the court to prove the facts. It is also mentioned, it is also described in Indian Evidence Act. So, Section 5 tells what type of evidence should be produced before the court to prove the facts established in the court. Students, here we see Section 5 confines producing of evidences. And it says that, it means according to Section 5, evidences may be given. Section 5 says that, Section 5 of Indian Evidence Act says that evidence may be given to prove, evidence may be given to prove the fact in issue or relevant fact. It means only and only any evidence that proves, that connected the existence or non-existence of fact in issue or relevant fact, that evidence shall be produced before the court. But except these, no other evidences shall be produced. It means only those evidences are produced before the court by the witness, those are relating to the existence or non-existence of fact in issue or relevant fact. Except these, no evidences shall be produced. Only and only those evidences are produced that is relating to the existence or non-existence of relevant fact or fact in issue. So, Section 5 confines the producing of evidences. Any one evidence cannot be produced. Any evidence is produced before the court when they are relating to prove the existence or non-existence of fact in issue or relevant fact. Except it, no other evidences shall be produced. So Section 5 is called Pillar of the Evidence Act. Section 5, Pillar of Evidence. Okay? And if you see that there are three main principles, those are mentioned in the Indian Evidence Act. The first one is only those evidences are produced before the court to prove the relevant or fact in issue. Except it, no other evidences shall be produced before the court. It means any evidence that proves existence or non-existence of the fact in issue or relevant fact, only those evidences are produced before the court. The second one is best evidences should be produced before the court. And the third one is exclusion of hearsay evidence. It means hearsay evidence should not be produced before the court to prove any fact in issue or relevant fact. These three principles are known as basic principle of Indian Evidence Act. And Section 5 is called Pillar of the Indian Evidence Act. So it is very, very important. So I have described Section 5 to which one of the following sections of Indian Evidence Act 1872 provides that evidence may be given of facts in issue and relevant fact. Section 5 explains it. Okay? So C option is correct. Next, question number 3. A is tried for the murder of B by beating with club with intention of causing his death. It means A has the intention also. A has intention to cause his death by beating. A's trial, which one of the following is not a fact in issue? Which is not a fact of issue? A, A's beating with the club. It is a fact in issue. A's conversation with C. Conversation with C. Whereas we see that A is tried for the murder of B by beating with the club. Conversation. A is causing B's death with the club. It is also relevant. That is fact in issue. A's intention to cause B's death. It is also. But B option, conversation with C, it is not fact in issue. It may be relevant, but not fact in issue. It is not main subject that is disputed between the parties. So B option is correct answer, and here B is true. Okay. Next, question number 4. A is tried for murder of B. Which one of the following is not a relevant fact? A is tried for murder of B. Which one of the following is not a relevant fact? A had murdered X and B was aware of that. B was a drug addict. Which one of the following is not a relevant fact? It means that is not relevant. So A had murdered X and B was aware of that. B knows that A had murdered X. Okay. But B was a drug addict. It is not relevant. If it is said about A, it may be relevant, but it is said that B was a drug addict, so it is not relevant. And here the question, which one of the following is not a relevant fact? So the option B is correct answer. Okay. Question number 5. In any suit or proceeding, evidence may be given. If you see in the section 5, evidence may be given in any suit or proceeding to prove the existence or non-existence of fact in issue or relevant fact. And except it no others. So if we see here, existence or non-existence of every fact in issue only, whether I have said you, evidences may be given under section 5 in a suit or proceeding to prove the fact in issue or relevant fact. So here every fact in issue, only fact in issue, whereas I have told you not only fact in issue but relevant fact is also to be proved. So it is not proper. Second one, existence or non-existence of every relevant fact only. Next, every fact which is connected with a relevant fact are fact in issue. Existence or non-existence of every fact in issue and of such other facts which are declared to be relevant by Evidence Act. It means a relevant act. Because existence or non-existence of every fact in issue, it is a fact in issue. And the second, and of such other facts which are declared to be relevant by the Evidence Act, it means relevant fact. From section 5 to section 55. So option D is correct answer, because it tells the existence and non-existence of existence or non-existence of every fact in issue and relevant fact. Okay. Next question. Question number 6. Under Indian Evidence Act, evidence may be given in respect of fact in issue only, relevant fact only. Option C, fact in issue and relevant fact. Fact in issue and relevant fact. It is told, it is mentioned in the section 5 of Indian Evidence Act. Evidences may be given in any suit or proceeding to prove existence or non-existence of fact in issue or relevant fact. So the correct answer shall be C. Okay. Next question 7. Whether evidence of non-existence only of a fact in issue may be given? Yes. Yes. Because evidences shall be given, may be given. Of what? Evidences of non-existence or existence of fact in issue or relevant fact may be given under section 5 of Indian Evidence Act. So the correct answer is A. Okay. Next, facts which form part of same transaction are relevant under which section of Indian Evidence Act? It means section 6 says that facts though are not in issue, it means fact in issue. Facts though are not facts in issue, fact in issue, yet are so connected with fact in issue as to form a part of same transaction, whether it takes place same time place or different time place. It is mentioned, it is said in the section 6 of Indian Evidence Act. Here, facts which form part of the same transaction are relevant under which section of Evidence Act? Section 6. Okay. So A is true option. Question number 9. Under which of the following sections of the Indian Evidence Act, the doctrine of res gestae has been dealt with. It means which section provides the principle is relating to the principle res gestae. Section 6 is relating to the doctrine of res gestae because facts, though not fact in issue, yet are so connected with fact in issue as to form a part of same transaction, whether it takes place at a same time or it take place at a same time, place, or different time places. So it is explained in the section 6 of Indian Evidence Act. So the doctrine of res gestae is explained in section 6. The doctrine of res gestae, same transaction, is explained in the section 6 of Indian Evidence Act. So correct answer is B. Correct answer is B. Which among the following sections of Indian Evidence Act 1872 is an exception to the general rule hearsay evidence? I have told you, hearsay evidence must be excluded. Hearsay evidence should not be produced before the court to prove the fact, whether the fact in issue are relevant fact. Hearsay evidence should not be produced in the court. So section 6 is the exception. Res gestae is the exception of hearsay evidence. So section 6 is correct answer, and section 6 is mentioned in option A. So option A is correct. Question number 11. A wife had only seen a speeding vehicle which had crushed the husband at a little distance. Okay. It means at a little distance her husband was crushed over by a truck. She had not seen the accident herself. The husband died of heart attack. Okay. A day later, can wife evidence be taken what the injured husband said? Because when the accident was taken after a day, it means after the accident, it means other day, second day, he died with heart attack. So when he was crushed over, when he was crushed by a truck, he told all things to his wife. Here is a question is asked from you, that here is a question is asked from you. What? The question is asked from you that his wife may come as a witness and gives evidence. According to section 6, she is a competent witness because it is relating to res gestae. whether the facts, whether the fact not a fact in issue, whether the fact not a fact in issue, but are so connected with fact in issue as to harm, as to farm. It means it is connected with fact in issue as to form a part of same transaction. It is a connection. So wife is entitled to give evidences, though her evidence is known as hearsay evidence, but she is entitled to produce such hearsay evidence in the court. So, yes, it being dying declaration, no, it is wrong, dying declaration not. No, it is merely hearsay evidence. Yes, it is a hearsay evidence, but such hearsay evidence may be produced as a registry. So, option D, yes, it being a part of registry, because same as to form a part of same transaction. Where same transaction is mentioned, it means it is a part of registry. So here option D is correct answer. A is accused of waging war against the government of India by taking a part in an armed insurrection in which property is destroyed, by troops are attacked and goals are broken open. A is not present at all of them. The occurrence of these facts is relevant because they constitute a motive for relevant fact. No. The so preparation for relevant fact, they are effect of relevant fact. No. They form part of general transaction. It means same transaction. So option D is correct answer, and it is based on section 6 of the Act. Next, A is accused of the murder of B by beating his. In this case, which fact is relevant? Whatever was said by A or B at the beating. Illustration first of section 6. If you study, the answer of the question shall clear. A is accused of the murder of B by beating his. In this case, which fact is relevant? Whatever was said A or B, that is relevant. Whatever was said by bystanders at the beating, it is also relevant. Which is contained in the electronic form? All the above. Here all the above is correct answer. Which is contained? Because first is also correct, second is also correct, third one is also correct. Which is contained in electronic form, that is also relevant. Next question. A fact farming part of the same transaction is relevant under section 6 of the Indian Evidence Act if it is in issue and has occurred at the same time and place. If it is in issue and has occurred at different time and place, it does not mean. Whether it takes place at a same time place or other time places. Other time place, it means different time place. Though not in issue and may have occurred at the same time place or at different time place. Though in issue must have occurred at the same time place. Here the answer C, option C is the correct answer, because facts though are not fact in issue. Facts though not in issue and may have occurred at the same time place or different time place, it is also form as to form a part of same transaction. So res geste, principle of res geste is also mentioned here, and section 6 and option C shall be correct answer. Fact which are so connected with another fact as to form part of same fact shall be said to be relevant fact if they happened at the same time, they happened at different time, both, okay, same time place or different time place, both are correct. It means option C is correct answer. Okay, today I complete my question. Next day, it means from Monday, I shall start. Okay, thank you, that's all.